Welcome everybody, good morning, good afternoon, good evening, wherever you are. I have the pleasure to take you today in this hour through an interesting topic, IP in emerging markets. And myself, I'm Jan Brede, I'm a German attorney working for Dänemeyer in Dubai since 2014. And we have a very exciting panel today from 4 continents, our experts joining me, and they will introduce and illuminate us about some topics in emerging markets, what is happening in the COVID times, in these hard times, in several markets. And in the second part of our talk today, we want to talk a little bit more about anti-counterfeiting, customs, what can we do, how can we help clients and associates to tackle these very different and difficult issues. So without much further ado, let me please introduce our panelists today. Ladies first, please. Larissa, can you please introduce yourself?
Hello, thank you. So my name is Larissa Lysenko. I am a lawyer and Russian trademark and industrial design attorney. I am working in the Russian office of Dänemeyer, which is located in Moscow. I practice IP more than 20 years and advise the clients on all aspects of IP, including consulting, clearance, filing strategies, opposition proceedings, managing international IP portfolios, and development of complex anti-counterfeiting strategies, including on the internet. Among others, I advise the clients on prevention infringement of third parties' rights and evaluation of trademark invalidation risks due to non-use. I represent the clients in the Russian Patent Office, Chamber for Patent Disputes, Anti-Monopoly Service, Customs, and Specialized IP Court. I may say that I obtained a unique experience as a legal consultant and in-house lawyer, which makes me capable to provide the clients with the most relevant and practice advice.
Thank you so much. May I now ask Ms. Suchi from India?
Hello everyone, my name is Suchi Rai and I'm a registered Indian patent agent. I'm located at Dänemeyer SNA India office and I've been practicing in IP for more than 10 years now. And I would say thank you for making a panelist here.
You're welcome. Please, Claudio from Brazil.
Well, I'm very happy to have the opportunity to join this panel. My name is Claudio Chabas. I'm registered to the Patent Office in Brazil. I'm specialized in patent and trademark prosecution since 1990, and with a background in industrial control engineering for 15 years. I'm happy to have the opportunity to present topics about Brazil in this panel.
Thank you. Welcome again. Christoph now from South Africa.
Very much, and my name is Christoph van Zyl, and I'm a South African attorney and trademark attorney with experience in the filing, prosecution, and enforcement of trademarks in South Africa and the rest of Africa. And I am based in Luxembourg, but I am responsible for our full satellite office in South Africa, where my partner Robin Merry takes care of the patent filing practice. So we can help clients both from in Europe who want to file in Africa, as well as domestic clients in South Africa who want to extend their patent and trademark rights overseas.
Great. Please, Shaukat from Pakistan.
First of all, thank you very much for this wonderful opportunity. My name is Shaukat Ali. I'm working since 2019 in Dänemeyer Associate Dubai office. I'm Pakistani trademark lawyer. I have more than 7 years of experience in Pakistan, especially to the trademarks.
Good. Then last in the round is Yasir Masood from our Dubai office.
Yes, thank you very much. I joined Dänemeyer Dubai in 2016. Coming from Germany, I work as a trademark lawyer. We from our Dubai office, we handle the whole MENA region from Morocco all the way to Shaukat in Pakistan. And in our trademark department, we take care of the whole life cycle of the trademark, from filing strategy to the actual filing, prosecution, legal advice, and enforcement.
Great. Yeah, welcome everybody. Nice to have you here. Let's go now into medias res immediately. So we wanted to know what is new, what is happening in these days in our countries. So please again with Russia.
Okay, thank you very much. Well, we all know that COVID-19 pandemic changed our lives completely. In Russia, a number of people lost their jobs in these times. Others changed their spheres of activity or obtained additional education while staying at home, which was not so easy. Small and medium businesses mostly suffered, and not all of them managed to survive. In Russia, however, government supported business and families, and people consolidated. Well, such extraordinary situations caused a burst of development of scientific and creative thoughts in Russia. The number of patent applications within the period of the year 2020 and 2021 increased. By date, quite a number of patents for inventions relating to vaccine formulations are granted in Russia. If you make a search for patents, you will see that more than 100 patents are granted in the Russian Patent Office. And they include methods of treatment and disinfection, devices for disinfection, vaccine compositions. Well, as for those related to COVID-19, the most known in the world now, as far as we know, is Sputnik V from the Gamaleya Research Center, Epivac Corona by Vector, and Covivac, which was just recently in February 2021 recorded with the Russian Patent Office. We know that Sputnik now is approved for use in various countries, and we may state that pandemic situation resulted in transformation of business and common life, including our mind. Attitude to various things changed dramatically within this period, what we see. By general rule, for example, monetization of IP is quite important, as it is one of the ways to promotion your ideas and goods. In the tough times of pandemic of coronavirus, this statement turned to be invalid. Why I say so? Because a lot of museums, exhibitions, theaters provided online broadcasting for free. Libraries provided online books, and famous actors and dancers gave lessons and masterclasses. It seems that monetization of IP, which is quite crucial in common life, became less or even not at all important. And self-expression, self-realization, and confession to the public became the main sense of some within this period of time. What also should be mentioned, I think, it is change of attitude to various deadlines by Russian officials. As we know, one of the critical aspects of obtaining protection of IP and its further maintenance is deadline. While COVID times, they have become even more critical. And professionals and clients took advantage of the situation when quite strict requirements that commonly are applicable by the Russian Patent Office to the documents and deadlines were softened. Thus, last year, governmental decree of the Russian Federation of 2020 on extension of some terms for implementation of various legal actions, including payment of patent fees, allowed business to maintain deadlines for various IP and keep the IP alive. The said decree provided some additional time up to December 21st of 2020 for the deadlines, normally expiring within the time starting from March up to November 2020. I should say that currently the situation with COVID is not considered as the ground for extension of deadlines anymore. What should be also mentioned is increase of activity by applicants. It means that the business is gradually recovering, and as a consequence, the number of applications for both patents and trademarks are also gradually increasing. However, the opposite side of the coin in any extraordinary times is rise of unfair behavior. What we noticed is increase of the number of applications for registration of the trademarks incorporating corona and COVID words with regard to various classes of the International Classification of Goods and Services. The right holders of the famous trademarks were monitoring the situation and immediately filed oppositions against provisional legal protection to such kind of trademarks. We know that this situation is under special control of the head of the Russian PTO, and we hope that the file designations containing COVID and Corona words will be finally rejected registration as contradicting principles of humanity and morality.
Very interesting. I think you really made the best out of it, of the situation, that you were able to recover and to come up with not only with a very famous and hopefully very useful vaccine, but also you have more trademarks running activities now from the human level and also from the business level. It's very interesting. Suchi, how can we compare the situation in India?
With respect to the COVID situation and recent amendment in laws, I would say India, which is often described as world pharmacy, supplying vaccines to more than 70 countries on a humanitarian and commercial basis, is spearheading the move to get a TRIPS waiver at the World Trade Organization. In October, India has petitioned WTO to allow member countries to waive trade obligations and restrictions under the intellectual property rights, including patents. And this would enable India and other pharma-producing countries to distribute COVID vaccines and other related technologies to better handle the pandemic. They submitted their request to the WTO TRIPS agreement and asked for the waiver to remain in place until most of the world has been vaccinated against COVID-19. So the benefits of waiving the IP rights from COVID vaccines and other technologies are that it will reduce the cost of vaccines substantially and enable free flow of medicines, easy technology transfer across the world. And such a waiver would enable greater access to affordable COVID-19 health technologies, including vaccines, in particular for the developing countries. Apart from this, with respect to the Indian Patent and Trademark offices, there was changes in the proceedings, like all the official hearings were conducted virtually. Earlier, there was a mix of physical hearings and virtual hearings, but during the pandemic times, it was all virtual hearings, which was convenient for both the officers and the applicants and agents. And with regards to the official deadlines that were falling in this COVID period, that's starting from the 15th of March to 2020 to 14th March 2021. So any deadlines falling in this period was relaxed by the government, and with the recent court order, a limitation period of 90 days is given so that any deadline falling from 15th March 2020 will get a relaxation period of 90 days starting from 14th March 2021. And any such missing of deadlines were able to be corrected by filing petition under the special rule 66 that was in respect of the COVID situation. And all such requests were allowed by all the controllers and registrars. For example, the renewal fee, if any, was be able to be paid without filing an extension request, an official fine for delay. Apart from this official deadline extension, there was also relaxation with respect to the filing of original documents and notarized documents. So earlier it was required to be filed within 15 days from filing it online. But during this pandemic situation, it was not required to be filed along with online filing, and it was only required to be submitted while requested by the officials. So these were the changes that were made during the COVID situation, and it helped all the IP right holders.
I have one question. So you mentioned a WTO proceeding, and I know from other proceedings they can be quite lengthy. And is there anything, you have any idea how long
Yes.
it might take a decision in this
Yes.
specific case?
Yes, so apart from this, Indian Patents Act 1970 provides provisions for the use of patents by the government. So the government can use the patents for the emergent situations like pandemic of COVID-19, and they do not need to pay any royalty to the owners of the patent. So that is one situation that can be used to ignore the delay.
Okay, very good. Did you notice any change in the trademarks, like more trademarks filed with Corona or COVID inside?
So the changes were respect to the relaxation in the official deadlines.
Thank you so much for this interesting overview of the situation in India. And maybe again, please have now our colleague from Brazil, Claudia. What's happening in Brazil?
Well, the good news from Brazil is that we are receiving the vaccines from India. We're receiving vaccines from Russia to produce the Sputnik in Brazil. And the good news from the patent office. But let me place you first, where is Brazil as an emerging market? In 2019, Brazil was the fourth major foreign investment destination country. And when compared to the GDP, it was the second major one, only behind Singapore. In 2019, the GDP was about $1.8 trillion with a population of 200 million people. Together with China, India, Russia, and South Africa, Brazil forms the BRICS, which represents 42% of the worldwide population, 30% of the worldwide territory, 23% of the worldwide GDP, and 18% of the worldwide trade. Touching on patents, in what we see in Brazil with the patent office is a great move that started a few years ago with the head of patents and was consolidated with the change of government, straightening ties with Western countries. I am looking here on my paper because I'm always giving numbers. Brazil has been celebrating PPH agreements with any patent office approaching the Brazilian PTO and committed to cut down the known pendency of more than 10 to 14 years to a reasonable one of 6 to 8 years to get a patent in Brazil, and fixing a 2 years timeline to attack 80% of the backlog in Brazil of about 150,000 patents application pending. After 2 years, in March 2021, right now, 2 years later, the backlog is of 76,000 patent applications. The Brazilian patent law provides for 2 terms of protection, 20 years from the date of filing, but not less than 10 years from the date of grant. That means that the Brazilian Patent Office, they are not willing now to grant patents with more than 10 years from filing. To this end, the PTO is issuing preliminary office actions, requesting the applicants or encouraging the applicants to conform the Brazilian claims to the claims granted in country with substantive examination. Through PPH agreements, patent applications passed for allowance in about 6 to 10 months from joining the PPH agreement. With the green patents, expedited examination patents are allowed within 2 years or less. Expedited examination is also available for pending applications that are supporting or are used for a cease and desist letter to the infringers. But the Brazilian law does not provide for extensions beyond the 30 months term for entering with a PCT application. The Brazilian patent rules provide for reinstatement of the right to file PCT applications when there is an evidence of duty of care, similar to the rule 49.6 from the PCT. Evidence of COVID-related impediments, they have been accepted for extensions of deadlines, at least in patent matters. Last but not least, please remember that there are broad grace period provisions for patents, utility model applications, and industrial design registrations in Brazil. Now, passing to trademarks, the Madrid Protocol, effective as of October 2019, is the most relevant occurrence in Brazil, in the Patent Office. There are many questions still open, as for instance, divisionals of positions in Brazil. And what the instructors are not aware is when they have a multi-class application filed in Brazil and one of the classes is rejected, the other pending classes, they are placed in abeyance until the decision is taken about the outcome of the other class. That can take some years. So in this case, when there is a class that is has a risk to be rejected in Brazil, the option would be to file single national class applications in Brazil. Otherwise, you will stay in line for two or three years. In numbers, Brazil received from the Protocol Madrid 2,900 designations, which corresponds to about 30,000 classes. And in turn, Brazilian firms have only filed 185 multi-class applications corresponding to 300 classes. What regards to customs and the patent office, the trademark registrations with a description of the goods and photos, they are made available for consultation to the customers authorities if the trademark offices owners submit these description and photos to the National Directory of Combat to Trademark Counterfeiting database of the PTO.
Claudia, can we talk about this in the second part more in depth?
Okay. Well, the other topics would be the 10 trademark requirements and for future lack of use. We can talk about this later.
Great. So you mentioned that the trademarks, if I have to say, two classes, one class is not objective, would go through, the other one has a problem, maybe an objection, opposition. This would block the entire registration.
Exactly.
Right there, because, for example, in the European Union, you could then just split the trademark and say, okay, this class goes on, and the other one we talk about it separately. So at least one part of the trademark is going through. There's no such option.
Yes, not yet. The split is what I mentioned as to divide out the application divisionals, right? The situation in Brazil is that we have national, in the national law, there are some rules that they're not matching the Protocol Madrid yet, and they're working on this. So to date, if you have a multi-class application and one of the classes is rejected, the other will be pending on the decision of this class. Now, recently, it takes about 2 years or even more to decide on an appeal, because if the class is rejected, you file an appeal. But the backlog for trademarks is huge, and they're cutting down. They're doing the best efforts, right? They're doing the best. But for now, as long as there is not a rule allowing the patent office to divide out, to split the application, our recommendation would be, file national single class applications, just to not put the other on abeyance.
It is great. You mentioned that the patent office has anyway been able to cut down the examination time for the patent significantly. This is reminding me of the situation we had in India a couple of years ago, where there was a huge backlog also in trademarks. And I think, Suchi, that now the Indian patent office has done a great effort to come down to acceptable, reasonable terms in trademark examination.
Yes, and in trademarks, normally now, without opposition, a regular trademark application is taking about 9 months, 10 months to allowance. That's good. That is good if compared to 2 or 3 years that in the past.
Quite fair. Okay, thank you so much, Claudia, for this insight. And now let's please hear Christoph with some news from the next BRICS country.
Thank you very much, Jan, and it's so nice to talk to colleagues all from a different BRICS country, because at Denimo we seem to be one of the few firms in the world that has an office on all continents, and certainly an office in each BRICS country. And I found very interesting what Suchi was saying about access to medicines, because this initiative that India has to petition the World Trade Organization to suspend patent rights until the end of the pandemic is an initiative that is supported by several African countries, including South Africa. And from a policy perspective, what a lot of the rest of the world don't realize is that the COVID-19 pandemic is not actually the first pandemic that we were dealing with on a serious level in Africa, because since the late 1980s, and especially in the 1990s, the major pandemic, especially in Africa, that is still ongoing relates to HIV and AIDS, where South Africa and many African countries had a very bad experience in terms of gaining access to medicine. If one reads in the media, for example, there are several people who participated in in AIDS treatment trials in the 1990s, who were kept very healthy for 5 or 10 years. But after those trials expired, the very people who participated in those trials could not afford anymore the medicine that they were given during the trial. And it's really a human rights and a humanitarian issue, because a lot of those people died. And this COVID pandemic is now the second pandemic that Africa is dealing with. And certainly most African countries support the petition to the WTO to obtain some kind of equity on the world stage so that there's access to medicines. However, another aspect of this pandemic that is very relevant to the IP laws in South Africa and other African countries, and I also understand from Sushi in India, is that states, including the government in South Africa, might be doing very well to petition the WTO, but they really need to have a look at the domestic laws to see if there isn't something that can be done as an emergency measure in the shorter term to grant access to medicines. And here, what is very interesting is that the South African Patents Act has 3 measures that are available to the state and to generic manufacturers to allow better access to medicines. The first is there's a system of compulsory licensing where a generic manufacturer, and there are many in South Africa, could approach a patent rights holder and obtain firstly a negotiation of a license to manufacture, for example, a vaccine. There's a compulsory negotiation phase, and then this whole process is subject to a judicial process before the Commission of Patents. And it's very complicated. It's a very long process, and the fact that a prior negotiation has to take place means that we're talking about a very long time before a compulsory license can be issued. And what the states really need to go and look at is TRIPS does not require a prior negotiation. The measures in the South African Patents Act, which existed prior to South Africa joining TRIPS, are in fact more onerous than what TRIPS requires. So on the one hand, yes, I think the WTO is one forum to raise these issues, but the other is for countries like South Africa, countries like India, countries in Africa to look at their domestic legislation to see what can be done, as is the case in Europe and the United States. In the US and in Europe, there are measures that allow, for example, the EU or the state to ban exports if there's not enough local supply for a vaccine. And we don't have similar laws that allow that type of executive order in South Africa. And all of this action would actually be perfectly aligned with the current version of the TRIPS agreement that South Africa signed. So at least on the pharmaceutical stage, the pandemic is the second time that access to medicine becomes an issue. And perhaps for the second time, another issue is not only the worldwide treaties, but the domestic legislation, which requires processes that are far too long and far too complicated in an emergency such as what we are seeing now. Besides the pharmaceutical aspects of COVID, there are a few practical aspects of the pandemic that are quite interesting, I think, more to IP attorneys, but also the general public. When the pandemic started, the South African state was very reactive. I think there were maybe 5 or 10 cases in South Africa when the original lockdown was implemented at the end of March 2020. And this was one of the strictest lockdowns in the world, perhaps fairly draconian to some extent. And 2 aspects that really hit businesses hard and that impacted IP were the ban of the sale of cigarettes and the ban and sale of alcohol, which we didn't see in many countries. And the ban of cigarette sales especially created the problem that people who smoke need to find cigarettes. So it's a case of, for example, if a person is addicted to sugar or drugs or tobacco, you cannot simply stop smoking for 3 months because the government bans the sale of cigarettes. And what happened is the dealers in counterfeit goods and also the manufacturers of illicit cigarettes gained a significant market value. This has been a major problem for manufacturers of tobacco who have for a long time been combating illicit and counterfeit goods in South Africa and goods going to neighboring countries, where suddenly after the pandemic we are seeing far more illicit goods in the market, which are often cheaper, and people who didn't in the past support purchasing counterfeit goods got into the habit of doing so. So the market has changed a lot, and this really creates a challenge for tobacco companies and their IP attorneys. But there are ways to fortunately combat these problems through the fairly effective anti-counterfeiting laws in South Africa. And with the sale of alcohol, really the issue was more of an economic one. Going beyond the policy considerations, there are a lot of wine manufacturers who could not export wine. There are a lot of alcoholic beverages manufacturers who were hit a lot harder than in other countries. So those are really not pure IP issues, but those are issues where IP law has become quite relevant, and also export laws have become quite relevant since the start of the pandemic. To wrap up on COVID changes, a really positive aspect of the pandemic has been its impact on the efficiency at the IPO. Basically, trademark renewals were always digitized, but patent annuities are becoming digitized, which is good news for Denemer and our clients, as this is one of our main markets. And also, as was mentioned, in India, a lot of administration in the courts was previously not digitized, whereas now we are seeing many digital hearings. And for example, me, based in Luxembourg, but running a practice in South Africa, I can now appear in a South African court, which I couldn't do in the past. So that would be quite interesting to actually appear in a court from outside the country. For me, that's one slightly interesting aspect.
That's very interesting. I think your country has implemented some very unique measures. It sounded a little bit like the prohibition times in the US 100 years ago, which, as we know very well, have not been very successful in the end. So let's see what is happening in Pakistan.
Yes, thank you very much for this wonderful opportunity. Despite this COVID situation, I would like to share some positive news from Pakistan, some projects and some new laws in Pakistan. So I will start with the China-Pakistan Economic Corridor. Pakistan is going to become an important trade hub between China, Central Asia, and Europe through the China-Pakistan Economic Corridor, which your people are saying CPEC in the short form. Also, in the project, there's a One Belt, One Road project, which started back in the year 2016, includes the largest deep sea port in the region, new rails, roads, and airports. Pakistan has a unique commercial position altogether bordering China, India, and Afghanistan. So let's have a look on the recent IP laws in Pakistan, which are also very significant. So Pakistan signed the agreement to the Madrid Protocol and become 108th Madrid Union member with effect from 24th of May 2021. Now the trademark holder of Pakistan will be able to protect their trademarks more than 100 countries by filing a single application at WIPO, thereby facilitating ease of doing business. The business community of other countries will also be able to get the protection of their trademark in Pakistan by using Madrid route. It's a win-win situation for the traders from both sides, Pakistan and trading partners, to get protection of the intellectual property right to promote genuine business in their market, as well as in the confidence of in the potential foreign investment. There is another news from 2020, which is also very significant for the local market. Actually, the upper house of the Pakistani parliament has passed the geographical indication bill. The GI law is much actually needed for the commercial tool to protect the cultural heritage spanning more than 5,000 years of the goods produced and manufactured in the country. Now, Pakistan will finally be able to claim and use GI goods for their goods, and other than 100 of products are expecting to registration. Some famous products from Pakistan I would like to introduce: some famous basmati rice, Hunza apricots, the Peshawari chappal, it is called sandal, actually is a leather sandal. Sargoda kinnus is the local language is saying kinnus, but these are oranges. Some Sindri mangoes, which are very famous mangoes, actually going around the world, is actually produced by the Pakistan in a province of the Sindh. And there are many other products. The move was very necessary to recognize and protect the country's GI in the interest of the public at large, as a part of more significant reforms to trade and industry aimed to be a betterment of the underdeveloped areas of Pakistan. So now I would like to share some news regarding the COVID, the deadlines extension in Pakistan. So starting April 2020, at the peak of the COVID time, the IPO Pakistan extended all the deadlines and suspended all the hearings till October 2020. So now everything is coming smooth. So now be careful. You have to file extension. You have to take care of your deadlines.
Yeah, that's good news, especially the geocommunications. So hopefully Pakistan will also join the Lisbon Agreement sooner or later. This could be very helpful also to boost this kind of business very needed for the population. So, Yassir, now coming to the Middle East.
Yes. Regarding the COVID leeway for protection of trademarks, this was in the very beginning that when the first wave of the pandemic hit us, March and April, the power of attorney was possible to be submitted within 2 months from the filing date, while normally for trademark procedures they have to be submitted at the time of filing. This leeway is not granted anymore. So at the moment, the only thing really where COVID is still a factor in the trademark procedures is that personal visits to the trademark office are restricted and hearings are still suspended. They're not held online, they're just suspended for the moment for opposition procedures or the like. We had the advantage that all trademark filings and renewal filings, all the related filings were already online before, so there was no disruption in filings as such. And in the meantime, the Dubai government has moved more and more services online. In general, we can say that I would say that the UAE government dealt quite well with the pandemic, that we have very little disruption at the moment. I think over 60% of the population has already been vaccinated. This might have, of course, logistical regions. We are also a rather small population as compared to all of your countries, and demographics are also different here. This would maybe lead to another topic. Big news from the region is that recently, actually with effect from 6 January 2021, the GCC Patent Office stopped accepting new applications. For those who don't know who's the GCC, this is the Gulf Cooperation Council, whose members are Bahrain, Kuwait, Qatar, Oman, the UAE, and Saudi Arabia. So they all had one, or still have one, unified patent office, but that suddenly, basically within 1 day of announcing it, stopped accepting new patent applications. So we're still kind of, let's say, not quite clear what this will mean for the future, but for the moment, no new applications will be accepted, which leaves the route through the PCT applications and national applications in the 6 countries. Another news during the pandemic time was that the UAE in the middle of 2020 again reduced the official fees for trademarks, which they already had done in 2019. Those were further reduced in 2020, but frankly, we are still one of the most expensive countries when it comes to trademark filings because of the single class system, rather high official fees, and also rather there's a number of requirements that, for example, in Europe and the US, we don't have, let's say, the legalization of the power of attorney. Then the local super legalization of the power of attorney is also still required. On a general note, as a general advice for clients who would like to file trademarks in the UAE or the region in general for Arab-speaking countries, it's advisable to not only file the version in Latin characters, but also in Arabic characters, so that the Arabic-speaking population will not be confused as to the pronunciation and might not just develop their own transliteration or phonetic of the phonetic with the phonetic version of the trademark. So this is basically it from the UAE. No other news as such.
Okay, great. Yeah, this stopping of the GCC applications came quite to a surprise, and we all know looking out what will be the solution, how it will go on. We know that there is a discussion going on in the council as to the future of the system, and in one way or the other, we are confident that we'll come up with the new version of it, hopefully. So that was, I think, a very, very interesting and nice overview. Thank you so much for this first part of our meeting. And I would say we can just use the rest of the time. We have around 20 minutes left for the specific topic of the day, which is the customs interception, anti-counterfeiting. How is this now organized and possible in these different and difficult times in your country? And we can start again, please, with Larissa from Russia.
Thank you very much. So the Russian Customs Register of Intellectual Property, TROIS, is one of the effective mechanisms ensuring protection of exclusive right of intellectual property rights. But not all of the IP assets may be included in TROIS. Thus, trademarks, service marks, objects of copyright and related rights, as well as appellations of origin, may be subject to inclusion to the TROIS. The maximum term of inclusion of the objects of TROIS composes 3 years, with the possibility to further prolongation. Upon expiration of the term of inclusion of IP objects into the TROIS, customs authorities proceed with ex officio inspection and informing the right holders on suspected goods. And what is important for such a big country as Russia, information on the recorded objects becomes available to all the customs posts, including air, traffic, road, railway, sea. And this mechanism presupposes active cooperation and interrelations with the customs authorities. And to facilitate customs operations, the right holder may specify the most important and the probable channels of imports to the Russian territory, and specific attention will be paid to these specific channels by the customs authorities. We should say that commonly a lot of counterfeit is still coming from China. Big companies, including foreign companies, actively use TROIS and educate customs officials by arranging various relevant seminars where they provide the most important information on proper definition of counterfeit, distinctive features of the original products, etc. So we should note that there is a risk of exclusion of the object from TROIS in case of non-cooperation of the right holders with the customs authorities or failure to meet the deadlines for provision of the requested information. I wanted to also mention that according to the current customs code and World Postal Convention, counterfeit and pirated items are prohibited from sending in international mail and must be returned to the sender. Thus, the customs is also quite active in checking the mails items, and we have such reports from the customs to our clients, and we received just recently relevant requests. So not only TROIS, but there are other effective instruments and tools for combating the infringement of rights, including unfair competition, and they are anti-monopoly service, courts, including specialized IP code.
Oh, very good. So we have confirmation that you still can effectively combat counterfeits in Russia. What about India? How is it in your country?
Yes, in India, with the National Customs and Border Protection prevents the cross-border movement of counterfeits and pirated goods, infringing intellectual property. Import of goods that infringe intellectual property into India is also prohibited under the Customs Act 1962. And to implement the same, the Government of India in 2007 notified the Intellectual Property Rights Imported Goods Enforcement Rules 2007, also known as the IPR Rules 2007, with the vision to protect the exclusive IP rights provided by the statute and prevent infringing goods transportation at the borders. So the IP rights that are involved are Trademarks Act, Designs Act, Copyright Act, and GI Act. And a notice in writing by the right holder is required to be submitted at the port of import of allegedly infringing goods requesting suspension of clearance of such goods. The notice is then registered by the Commissioner of Customs for a minimum period of 1 year, subject to the execution of a bond and an undertaking to protect the importer, consignee, and the owner of the goods and the competent authorities against all the liabilities and to bear the cost towards destructions and detention charges till the time of destruction or disposal, as the case may be. And the right holder also executes an indemnity bond indemnifying the custom authorities for all the liabilities and expenses on account of suspension of the release of allegedly infringing goods. So for giving such notice, or initiating the procedure by the custom authorities, the patentee or right holder is required to give a written notice to the Commissioner of Customs and requesting to suspend the clearance of counterfeits or infringing goods. The documents or details required are the proof of existence and ownership of the valid IPR, that is a granted patent number or a registration certificate, then authorization from the right holder, like a power of attorney, and if the custom officers require any further information from the applicant, then the same is required to be furnished with the commissioner within 15 days of such request. And the right holder is also under obligation to inform customs authority if he ceases to be the right holder, like if there is change in the ownership or there is expiration of the registration, then right holder has to inform the custom authorities. And the notice by the right holder is either registered by the custom authorities or rejected, and that is within the time period of 30 days. And the validity of registration of the notice is of minimum 1 year, and it can be extended till 5 years.
That's great. So also we have another country where we can do a lot in terms of anti-counterfeiting. How's it going on in Brazil, Claudio?
Okay. Well, in practical terms, it's very difficult. You know, the Brazilian laws are very common to all jurisdictions, right? What we have in Brazil with the Patent Office that was created a couple of years ago, it's what it's called the National Directory to Combat Trademarks Counterfeitings. It's a database. It is strongly advisable, we advise that to our clients, to file a specification, to submit specification photos from the products that they believe they will be imported, the counterfeited products. And this database is available, is accessible to the customs officers at airports and in harbors. Brazil has a coastline of 9,000 kilometers. 9,000 kilometers. That's the distance from a flight here from Rio de Janeiro to Washington, right? That gives you an idea. Now, if the custom officer will check or will become aware if he has in hands a counterfeited product, or if he will contact the database, this is something that is beyond the control and responsibility of the patent office and of the trademark owner, right? But that is a good option because there are about 200 or 300 trademark owners that use this directory, yes. And when the customs officers contacts the database, he contacts also the legal representative for this trademark. We have now, these days, we received a contact from a notification from customs from a harbor that is in a location about, I would say, 1,000 kilometers far away in the South Brazil, right? And what the custom officer became aware is that the goods that were bearings for a components for a machine, they were branded with a mark that was not cited on the invoice of the exporters. So what the custom officer did was to check the database of the patent office, yes, and he saw that Dennemeyer, and well, in the case, my name, is a legal representative for this trademark. So he contacted us, but obviously for this COVID situation, there's nobody, and neither the owner from the trademark is willing to go to check and to make an inspection. Obviously, we are trying to get photos from the customs officers. They do not reveal the name of the exporter and the importer, but we have also already touched base with the importer of the goods, because he has all his production on ice. You know, that's how it works. Imagine that Brazil has filed last year about 250,000 trademark applications. Yes, and I see that it is for free. It is a service that we offer to our clients. I think that we guys in all our country, we should promote this option. Yes, most of the counterfeit products, as Larissa says, also they come from China. This is all the same situation.
This is great, and I completely agree with you that trademark owners are a little bit more active and help you, then you can transform this into a pretty much effective weapon to help them in their counterfeiting activities. Let me ask now Christoph in South Africa. What is going on?
It's really interesting what our colleagues have to say, because one thing that we've learned at Denemeyer about counterfeit goods is that it requires a global strategy to combat. And in fact, there's an article on our website where many of us in this panel were authors, where we realized quite a few years ago already that the definition of counterfeit goods is not uniform in most countries, and even the procedures vary greatly from country to country. In some countries, infringing goods are the same as counterfeit goods. In other countries, there are additional requirements for goods to qualify as counterfeit goods. And these differences make it very hard for IP Council to create a strategy, because basically every country, every region, and sometimes every city, for example, if it's landlocked or not, requires a different strategy. So turning to South Africa, we have really good anti-counterfeiting legislation. We have a Counterfeits Good Act, which specifically sets out the procedure to combat counterfeit goods and how to lodge a complaint. And in our law, there's a distinction between infringing goods and counterfeit goods. In essence, in South Africa, counterfeit goods are goods that infringe copyright, trademarks, or patents, but where in addition the actual goods are imitations of the originals. So there's an additional step for IP Council to prove not only that the trademarks, for example, are confusingly similar, but that when the two products are compared, the one product is a colorable imitation of the other. And the main distinction in the process is between how to deal with counterfeit goods that are coming through a port versus counterfeit goods that are already in the country, because South Africa is a very large country, and there are two scenarios that happen quite often. The one is that a client hears about goods that are coming through a port and fortunately has a customs recordal. If not, our clients learn the lesson very quickly that it's necessary to have a customs recordal. But we have to bear in mind that only about 3 or 4% of containers coming through the main ports are inspected, which is still, in global terms, a very high percentage. The other scenario is that a client discovers that counterfeit goods are already in the market and appoints an investigator, typically to find that the goods are located at a warehouse somewhere inside the country. And the two procedures are slightly different, because goods that are coming through the port first need to be stopped by customs before the client has an opportunity to lodge a complaint. If customs is not aware that the goods are coming through the port, either because they don't detect them or because the client doesn't inform them to look out for those goods, the goods go straight into the country, and then perhaps the client is lucky if they can trace the location where those goods are stored to lodge a complaint. So the best scenario is actually for our clients to first discover where the goods are coming from outside of South Africa, which, as Suchi says, is often from China. But what we've seen happening more and more is
exactly excuse me, that we have mostly the same source, but then the distribution system and is quite different. And I want to give now the opportunity of Shaukat also. You have also a Karachi port. What is going on in Pakistan?
Regarding the Pakistani point of view, custom offices are also available on the dry ports, airports, and on the seaports as well. Actually, in Pakistan, custom recorders are very effective. To prevent these counterfeit goods from entering in the local and international market, brand owners may enforce their rights to the Pakistan custom by filing a written complaint with the proof of their IP registrations. Right holders have the option to record their trademarks and copyrights with the custom so that the custom office will watch their IPR throughout Pakistan. Not only one port, throughout the Pakistan, it is very significant for the right holders to protect their IPR. Recently, Pakistani authorities have seized more than 40,000 books for entering in Pakistan. I don't know the source, but they have seized the books to entering in Pakistan. These are actually the pirated books. On the other hand, in Pakistan, criminal civil actions are available for the right holder to protect their brand. If the copyright is also registered with the trademark, then there's a lot of options for the right holder to go through with the civil actions or the police or even with the criminal actions from the Federal Investigation Agency. So it's quite effective in Pakistan for the custom recorder and regarding the anti-counterfeiting. So that's all.
Thank you so much, Shaukat. It was a very concise statement. Now, Yasir, please. We're also in Dubai. We have a hub in Jebel Ali. 40,000 containers coming through every day. What is possible here?
Yes, as you mentioned, the UAE has a very unique position as you can say it's a hub connecting east and west. So lots of goods go through the country. We have one of the biggest airports and one of the biggest seaports in the world. But the anti-counterfeiting system is quite robust. We can register trademarks for surveillance by the customs. This is possible in 5 of the 7 Emirates. The UAE consists of 7 Emirates. 5 of the Emirates have this trademark recordation system with the customs. In the other Emirates, you would have to lodge a complaint if you have a suspicion coming in. The customs authorities will then monitor the incoming goods. But what should be kept in mind, unlike the European Union, we don't have a unified system in the GCC countries. So again, separate recordings will be necessary. The remedies include fines, seizures, destruction of the counterfeit goods. It should be mentioned that in the GCC trademark law, which has been, there is a unified GCC trademark law, which has not yet been implemented in the UAE. In that trademark law, also the seizure of goods in transit is authorized, but the UAE has not yet implemented that law, so goods in transit will not be seized in the UAE. As for parallel imports, this is also a bit complicated in the UAE and is only addressed in the commercial agencies law. This means your exclusive agent in the country can initiate seizure of parallel imports, but for this it's very important that the agency contract is registered with the Ministry of Economy. An alternative to the customs recorder here, the administrative action is very strong in Dubai, for example, through the Department of Economic Development. They have an online system where brand owners can register their trademarks, file complaints, and the office is very fast and takes action, takes seizures, raids, investigations, everything works very fast and efficiently. Otherwise, as Shaukat also mentioned, we have the criminal and civil action options.
Okay, thank you so much. So I'm looking at the clock and I see we are at the end of the session, almost perfectly at time. Big thanks again to everybody. It was so interesting to have all these different views from all over the globe. The topic was IP in emerging markets. I think we have learned that the IP is not so much emerging, it's already very developed, it's already there. We can do something in anti-counterfeiting terms. We are not scared by the COVID as far as the IP business is concerned. People have been very creative and active in keeping up the good humor. So I would say thank you again. It was very nice, very interesting. And anything else, we will have a Q&A session now in the live webinar. Thank you so much.
Thank you very much.
Thank you.
Thank you.
Thank you. Thank you. Have a nice day.